Good morning, good afternoon, good evening, everyone, depending where you are. I'm Michael Barassa. I'm with Fasken's Global Mining Group. And today is our third session of our PDAC seminar series. We have one more tomorrow, which will be on Indigenous litigation. But today it's mining at war. And we've had very good attendance so far. This is actually a test case for us in a way for the mining group. It's the first hybrid session that we've done. So there's many out there on your computers watching this right now, but we have people in the room with us today as well. So without further ado, I'm going to turn it over to my colleagues Andrew House and Cliff Sosnow.
Thank you, Michael. Good afternoon, evening, or morning, as the case may be. And Michael, I like how you put that, depending on where people are joining us. This is a hybrid session, which I am really pleased about. It's nice to be back at the Fasken Ontario headquarters. And thank you to those joining us in the room, but also those joining us in what's now become the traditional fashion from your home, wherever that may be. With the Russian invasion of Ukraine, sanctions law has truly leapt to the forefront of due diligence across all domains of business law, from financial transactions to M&A. And the global mining industry, with its intricate supply chains and cross-border relationships, is particularly vulnerable to sanctions enforcement. And that's why we've gathered here today, is to tackle this very vexing problem in the midst of what is meant to be a global recovery from COVID-19. And increasingly, we're hitting these kinds of roadblocks in redeploying assets and attempting to just make headway against what's been a really challenging time. The law of sanctions is complex. Of course, it's politically charged, and it's very consequential. Failure to adhere to these regulations can cost much more than dollars. There's actually a potential penal consequence. You can spend time in jail for violating sanctions law. For mining purposes and for the mining community, critical mineral supply is indisputably intimately linked to the security of states and any sustained war effort. And that is, tragically, where we find ourselves in a global sense. But that very supply is now potentially hampered by sanctions imposed by multiple allied nations in respect of the war in Ukraine. Today, we'll make our very best efforts to thread that incredibly difficult needle and address what I like to call the unknown unknown. Of course, that's not my quote, a very famous quote from Donald Rumsfeld. And let me just give you that full quote because I like it so much. Rumsfeld said, "There are unknown unknowns, the things we don't know that we don't know." And this is the quintessential legal problem. In the law, often clients come to you and say, look, I know what's wrong for my company. I know what I'm facing. When it comes to sanctions, there is this broad sense of not knowing whether or not you have a problem, but being most vaguely aware that something ominous may be on the horizon. Our purpose today is to make sanctions law slightly less ominous, slightly less unknown, and increasingly something that you can and must grasp as you move forward in your business operations. I should say this is a session about compliance, not circumvention. As you'll hear from Cliff in a couple of moments, these regulations are very serious business and you break them at your peril. Our purpose today is to help you not break them, but to recognize them in advance and to have a better understanding of what you need to do to face that challenge. And let me say in a profound way that many of us are grappling with the images we see on TV. I've referenced the fact that sanctions law is very difficult. It's a real problem for business operations. But of course, we're talking about sanctions by definition because of what's happened in the invasion of Ukraine. Sanctions is one of the tools in the international toolkit for dealing with interstate conflict. War's not new, but many of us, I think, have allowed ourselves to believe that history had somehow outgrown major state-to-state conflict. We've been roughly shaken from that erroneous assumption, and the images that we see almost nightly on our TV screens bring that home in a way that is hard to absorb. And as you make your way in your day job, in your business life, there is probably a strong sense of juxtaposition against what real people, real humans, are facing on the ground in Ukraine right now. So let's talk about sanctions. What are they? They are at bottom, a tool of foreign policy. And here's what Global Affairs Canada says about sanctions. They are a foreign policy tool used to address international peace and security concerns, gross violations of human rights, and significant foreign corruption. They form part of a comprehensive foreign policy approach involving political dialogue, engagement, and programming. Of course, they left out what's at the far end of that spectrum, just straight warfare. Sanctions are what you try to do as a member of the international community to avoid actual armed confrontation of an enemy. It's one of the, I would describe as early stage attempts to curb the highly negative behavior, illegal behavior of an adversary. I'm Andrew House. I'm the co-leader of Fasken's National Security Group, and I'm very pleased to be joined today by Clifford Sosnow, who is the co-chair of Fasken's International Trade and Investment Group. Cliff has had an incredible career, starting out at Global Affairs Canada across various private law appointments, the Canadian International Trade Tribunal, the Federal Court. I'll put it this way, if you've worked there, Cliff probably worked there before you. And one of the things that has been such a great privilege for me here at Fasken in recent months since the war began in Ukraine is to spend a lot of time with Cliff just grappling with how does this work? What do we say to clients when they are faced with what looks like a Gordian knot that just can't be untied in the sanctions universe? Being able to go to Cliff virtually has been a tremendous problem-solving capacity at Fasken for me and for so many others. So to be able to actually sit with him in person is, I don't want to make you feel awkward. It's an actual privilege. I'll also do a quick shout out to people that I feel like I've become friends with over the last few months, the good people from Webcast Guru. They're here in the flesh in front of me. These were my only friends at times during 2020 and 2021 as I sat alone in my basement doing webinars. So it's nice to see you guys in person. And of course, to all of you who've been able to join us today here at Fasken in person. I know we're still adapting to this. What we will do today is to take questions from the floor here at Fasken, but also from the many of you watching online. And please, as you listen, if things are not clear or you need it clarified in an additional sense, don't be shy to put a question through and we'll field those. First thing I'll do is put up a very familiar picture with an overlay. What you see in front of you right now, of course, the world map. In black, you will see the top 20 or so most highly valued mining jurisdictions. And the overlay in red are countries that are sanctioned. And what you'll notice is the cross-reference between those two. Many of the best places in the world to mine also are places of high political instability. That's increasing exponentially in the last few months. The context for our talk today is obviously the war in Ukraine, so we'll focus much of our discussion on Canada's sanctions in relation to Russia. But it's critical to remember that there are other sanctioned countries. In fact, this has been an ongoing process for any number of years for Canada in trying to deploy that foreign policy tool. So as you can see, many jurisdictions are subject to Canadian sanctions. These jurisdictions are also the targets for a lot of mining activity. Critically, you'll note that Canada and the US are listed as high-value mining jurisdictions. But as Cliff has pointed out to me a number of times, the fact that your mining operation is in Canada does not mean that you are completely devoid of any sanctions risk. And that's because of the investment profile of many mining operations across those countries depicted in black. They're not sanctioned countries, but there will be investment activities that could bring you into that sanctions universe. Maybe you've been there for a while and didn't realize it. Maybe this is a moment to grapple with the true impact of the Russia sanctions, but also sanctions imposed on other countries by Canada. It's also important to note that well, I think I'll save that point for Cliff. I think that is an important thing that I'm going to let the true expert describe. Let's move for a moment to the question of are sanctions having an impact? Are they actually working? There's this terrible conflict in Ukraine. There's a military response underway. So many allied countries are part of that military response in terms of providing materiel, We've even seen Canadians travel, not under the auspices of the Canadian government, but as private citizens, to fight in Ukraine. But in terms of the Canadian government's response in an economic sense, is it having an impact? So what we know so far is that 1,000 companies have curtailed their operations in Russia. And you can think of the many blue chip giants who have said, enough is enough, we're pulling back from our Russian operations. 325 of those companies have withdrawn completely from Russia. There's been a 22% decline in the number of M&A deals concluded in Russia during the first quarter of 22 as compared to 2021, and a similar drop in the announcements of greenfield foreign direct investment projects. So this is having an impact. The value of the Russian ruble has collapsed and then subsequently, oddly and surprisingly, rebounded, but it remains an incredibly unstable currency situation. And as a result of the divestment and decline in foreign direct investments, economists are forecasting an economic contraction in Russia's overall GDP of 15%. This is serious. If you are a country that has turned its attention to presence in global markets and attracting global investment, this is a real problem for you. Interestingly, you see the Russian state, the Russian economy literally soldiering forward. And what we'd like to grapple with in the next few minutes is why that's happening and why the effect of these sanctions is not maybe producing outcomes that are more rapid. One of the challenging things about sanctions, as they've been studied over the years, is that they appear to be a steady drip. The impact is not felt immediately. The theory is an economic shock causing either the population to exert pressure on the leader or elites within a society to exert pressure on the leader. You heard stories early on in the Russian conflict about oligarchs having their villas door knocked by the Italian police, property seized, yachts being seized all over the world. One would assume that if there is a power structure around Vladimir Putin, these gentlemen, and they are primarily gentlemen, would be very much of a mind to say, hold on, are we on the right path? My property is being seized, my way of life is being impaired, my wealth is being disrupted. Are we winning this war? Most accounts would say not clearly or not in the way that was expected. And it begs the question, why aren't the elites around Putin reacting to sanctions in a more rapid fashion? We're off topic from the law, but I just want to touch on this for a moment. Part of this has to do with the type of oligarchy that you see in Russia, and many of you will have experience with this by virtue of study and travel. Certain oligarchies work almost as a series of private armies where no one person has a monopoly on the use of force. In Russia, one person does have a monopoly on the use of force. The other oligarchs, they are not armed, they don't have that level of control. They are, in the description of one theorist, to be described as a sultanistic oligarchy, where there is one person who is in charge, has that power structure, monopoly over the use of force, and all other oligarchs are junior to that. And this is, I think, what we're seeing in Russia, such that although people's fortunes are being degraded and their wealth is being lost, they are still not in a position to actively pressure Putin to back away or change his course in Ukraine and in those disputed territories. Cliff, I'd like to just turn to you at this point and get your initial sense, and we'll move into this in more detail, about gaps in sanctions laws as they have been, and maybe we can begin to talk about what Canada has tried to do, because in many ways, although Canada is not a military leader vis-a-vis the war in Ukraine, they have tried to be a sanctions leader. And maybe you can talk to us a little bit about this.
Sure, and I thought that was a really good introduction, by the way. And surprising to many that Canadian sanctions are in many respects much more aggressive than European sanctions, US sanctions, UK sanctions, EU sanctions as it applies to Russia. And Canada has made it a political decision to be extremely aggressive, and we'll go through some of that aggressiveness. But I think it is important to highlight that sanctions really do have a cumulative effect over time. Over time, you start seeing disruptions in supply chains. Over time, you start seeing disruptions in the flow of cash, disruptions in the flow of high tech. And we'll talk about some of those disruptions as we go through the sanctions. But the sanctions are not a wall. And they're not this complete embargo. We'll talk about Russia. Business can still be done. And the problem for people, paradoxically, is that actually makes it harder because you need to actually know where the doors are to be able to get into the Russian economy and where not to. So you're dealing with something that's cumulative. You're dealing with a country that's not walled off. And part of that not walled off is I can do business with India. I can do business with China. I can do business with several Latin American jurisdictions that don't have sanctions. And so we've got gaps. And the way Canada is addressing them, and again, we'll talk about this as we go through some of the sanctions, is adding in new people, hundreds and hundreds and hundreds of new people, sanctioning new industries, sanctioning new services, sanctioning every conceivable bank that you can think of. And we will talk about some very, very extreme measures, and I'm going to put those terms as extreme measures when we get to a discussion about JVs and the risk of JVs with sanctioned partners in Canada. So countries are trying to fill the gaps, and we'll go through some of the issues that they're grappling with and how they're dealing with those gaps. But this is a fluid situation. And I think the headline at this stage of the game is sanctions are dynamic, they're constantly moving forward, and what you see today is not going to be what the sanctions law will be in 3 months and 4 months and 5 months from now. So people just need to focus on monitoring.
So, Cliff, we've set the international stage and provided that context, and I hope that's helpful. What I'd like to do right now, as we go to our first slide, is to look at just sanctions 101. Like, how do sanctions work generally, and why do we argue that they're impacting the mining industry in a particular way? And I mentioned this idea that the mining industry draws its inputs from such a broad and sometimes odd international base that it makes it, I think, particularly challenging for miners to grapple with sanctions given the far-flung areas from which those inputs are coming. Can you talk to us about why the mining industry in particular, maybe more than most, is faced with the complexity of conducting business in this era?
Sure. So first of all, when we're talking about sanctions in Canada, there's no one sanctions law. There's, I think, about 8 different pieces of legislation. There's the Special Economic Measures Act, which we'll be talking about, but there's the Magnitsky Act, there's the Criminal Code, there's the Freezing Assets of Corrupt Foreign Officials, the Public Officials Act, and on, the United Nations Act. So there's several intricate pieces of legislation. What we're talking about for Russia is the Special Economic Measures Russia regulations. And that's really become the heart of the sanctions beast when it comes to Canada's sanctions response. And the Russia sanctions, like almost all other sanctions, apply to anybody in Canada and Canadians abroad. So anybody in Canada could literally be anybody owned by a non-Canadian, could be any visitors to Canada, anybody here who's on a work permit. They do not have to be Canadians. They do not have to be Canadian-owned. It's literally anybody in Canada subject to these sanctions. And because it's Canadians abroad, Canadians, including Canadian corporations, take the sanctions laws with them when they go to other jurisdictions. And I will add that I'm talking about Canada, But the truth of the matter is that the US has a similar model, the EU has a similar model, the UK has a similar model. They're overlapping, they're not the same, they're not identical, but they're similar in, I'll point out some areas where Canada is literally the only one who's doing this particular issue. So as it applies to the mining sector, there's three areas that I think would apply and that need to be thought through when we're talking about sanctions. And the first is that the Russia sanctions, the sanction, I think, is 1,000 people and companies. And what we're talking about is everybody from Putin to his foreign minister Lavrov, to companies that are listed on the Moscow Stock Exchange, to virtually every single bank in Russia, to almost every single major company in Russia, including literally hundreds and hundreds of oligarchs. And a lot of those oligarchs are behind a lot of the mining that you see in Russia and a lot of mining investment. Now, why is this important? Because under the Russia sanctions, you can't transact in property that's not only held by a sanctioned person, but that's also held or controlled by another person on behalf of that sanctioned person. So think about distributors, think about agents, think about affiliates. They could be totally clean, but if they're dealing with that sanctioned person's property, that becomes problematic. Now, the sanctions say you can't only deal with it, you can't enter into any contracts relating to that property. So if you're in a mining jurisdiction, you want to get some ball bearings for some of your equipment, you know an Italian distributor, but that Italian distributor is selling ball bearings from Russia. And that comes from a manufacturing operation that's owned by a company that's legitimate, but in turn controlled by a sanctioned Russian oligarch. You can't buy those ball bearings. And one of the messages that's really important for us to be thinking about for sanctions is you really need to know the corporate structure behind the parties you're dealing with. It's just a headline. If you have no other takeaway from this conversation, it is always understand who's standing behind the parties that you want to be dealing with. And I will say that it applies to anything. You want to buy explosives, you want to buy tractors. All of those things, they're garden variety equipment. It's not the equipment per se that you're buying that's problematic, it's who you're buying it from. The other is Canada has now amended its sanctions legislation to cover literally every single property that you can think of. So virtual currency, any kind of digital assets, IP, licenses, so think mining concessions, think exploration rights. All of those would be considered property under the Russia sanctions, and anybody who's holding them on behalf of a sanctioned person is just prohibited from, you just can't deal with them.
I'm just going to bring up a slide that deals with a scenario that I think is it's pretty simple on its face. And what we're talking about here is very theoretical. I think the devil really is in the details, and that's why I wanted to do a scenario with you and run this through. So this is quite simple. This is the purchase of Russian coal. You can see it on your screens. We'll call it Canco. The Canadian company enters into a contract with a distributor to purchase Russian coal. The coal mine itself is the subject of a joint venture with one partner rumored to be owned by a sanctioned oligarch. Can Canco, the Canadian company, buy this coal from the distributor? For instance, does the distributor provide a distance from the potentially sanctioned Russian that would make it safe?
No.
Talk to us more about this scenario.
Yeah, I mean, it is deceptively simple, and unfortunately there's a depend here. But the reason that there's a depend is because the truth is that's your real life situation. Rarely do you get crystal clear clarity. And so a couple of things here. One is you've got a red flag in this transaction. There's a rumor that there's a sanctioned oligarch standing behind all of this. And it may be that this JV is owned or controlled by the sanctioned oligarch. If it is, then you have a problem. And why do you have a problem? Because the distributor is acting at the behest of the supplier. The distributor is not completely at arm's length to the supplier. It's acting under a contract. It's got certain territory. It can price it in a certain way. It can't sell to certain people. It has to follow certain obligations that the supplier imposes on the distributor. So the distributor is holding the coal and selling it on behalf of this JV. Now, if the JV is controlled by a sanctioned person, this oligarch, then that's property owned or controlled or held on behalf of a sanctioned person. And even though that distributor is not the same as the JV, you can't buy the coal or you're in violation of the sanctions. And you can't buy directly or through an agent indirectly. And by the way, it doesn't matter where the distributor is. That distributor could be selling the Russian coal out of Spain or out of Germany or out of China. And so again, the headline, always you'd need to always go back. You always need to go back and look who's standing behind the transaction.
So still dealing in scenario one for a moment, because I think it's useful to unpack this a little bit more while it is still a relatively simple scenario. Is there a scenario under scenario one where you could buy this coal? For instance, Russian coal deriving from a JV owned by a person who is not sanctioned. Would that be permissible?
Yes. Yeah. Now there's as we'll see, there's new sanctions that have been added that create difficulties in terms of picking up the coal. And we'll talk about some of the prohibitions there. I don't want to get ahead of ourselves, but we'll talk about that very shortly. But you raise a good point, which is just because something comes from Russia doesn't mean it's kryptonite, doesn't mean it's prohibited. If it's clean, we're not dealing with an oligarch, we're not dealing with any sanctioned parties rather, as opposed to an oligarch, because you could have an oligarch who's not sanctioned. Then you could buy that. It's in this particular one, we got a rumor. And we can't leave that rumor alone. And so we need to investigate whether there's something there. And I would add, and we can talk about compliance later, if you can't figure out if there's any value to that rumor, then to me, that's a red flag that's not resolvable, and you start thinking about walking away from that transaction.
Okay, so there's two important points I think that have just been made. And I had this experience recently with a client where I think the question was, after we went through sort of in detail these rules, his question is a very legitimate question. What can I do? Like, you've just now drowned me in legal fact and argument. What's left for me to do? And I think it's important that there is an answer. You can still buy the coal.
Yep.
Maybe you don't want to buy coal. Maybe you don't want to buy Russian coal. And those are policy choices you could make, but they're not legal restrictions, all things being equal. And I think we're going to speak in a few minutes about the fact that, all is not equal in many cases, particularly with recent moves the Canadians have made. And there was a second point I was going to make, but it's gone, and I'll get it back later. That's the problem with making lists.
Jog your memory.
So, it's important to, I think, illustrate that business can still be done. You'd want to think very carefully.
Very carefully.
And it's the trick really is in the due diligence, which we're going to come to in a few minutes.
Yep.
Let's move now to a slightly more complex scenario. And for folks wanting to ask questions, please, we can flip back to these, because I think this is where questions do arise is, well, what do you mean specifically? Now, Scenario 2.
So we can, before we get into that, why don't I do a little bit of scene setting for scenario 2? And sorry about that. So the Russia sanctions, we've talked about the buy side, but the Russia sanctions also affect the sell side. And there is a prohibition on selling anything to a sanctioned person or a person acting on behalf of a sanctioned person. And that's a fairly clear element of the law. But the law has been amended and will be coming into force very shortly that prohibits the selling of goods, Andrew, to anybody in Russia. And it could be a government agency. It could be any person in Russia. They don't have to be sanctioned. If you're selling them a particular list of prohibited goods, many of which are absolutely critical to the mining industry. And so I'm just looking at my list here. It includes rock cutters, coal cutters, tunneling machinery, bulldozers, again, ball bearings. None of that can be sold to a person in Russia or to a government in Russia. So, for example, if there's an RFP, so a particular agency in Russia that wants to purchase equipment to in turn be given to Russian mines, persons in Canada simply can't participate in that RFP if it involves this equipment. And I will say that that was introduced on May the 18th, and that comes into effect on the 17th of July. And that's the grace period. And if you have a contract that continues on after that grace period, that contract to continue on would be in violation of the sanctions laws. And so you'll literally have to freeze that contract. And so we'll talk about force majeure provisions when we talk about how to respond to sanctions. And this is one of the things to think about and keep in mind when we get to that. The sanctions, as I said at the beginning, are dynamic. You can be involved in a transaction, and that transaction gets hung up, and you really can't complete the contract.
So the picture that begins to form is one of, and you have to think about this really in at least 3 dimensions, if not more. You have people who can be sanctioned. Think of the list of oligarchs. You have goods that can be sanctioned. You've just mentioned some of them. That list was suspiciously focused on mining, I will say, as if maybe somehow there was a plan to focus on the Russian economy and its own reliance on mining.
Yep.
Let's give due to the Canadian government. And then you also have geographies which are sanctioned, and there are as part of Canada's Russia sanctions. In fact, the Ukraine version of the Canada sanctions deals with particular geographies within Ukraine.
Right, there's Crimea region of Ukraine.
And so this is not a unidimensional checklist. If it were, we'd have made one for you. This really has to do with thinking in multiple dimensions about the varieties of ways in which people, processes, goods, services, geographies are being controlled by the Canadian government along with allied governments.
Yep.
Let's switch to scenario 2, which is slightly more complicated. Canco has a subco in Turkmenistan. Subco signs a contract with a Finnish firm operating in Russia to provide bulldozers and consulting services. The Finnish company itself is not sanctioned. Is there a violation of Canada's sanctions laws arising? Fascinating choice of nationalities here.
Yeah, because that's usually the way these transactions work. So you know, the fact that the Finnish firm is operating in Russia, providing bulldozers and consulting services, the Finnish company, of course, would not be sanctioned unless it was owned by a sanctioned individual. And as we've talked about, there's no crime in doing business in Russia. It depends on what that business is. And so the issue is, not the Finnish firm. It's not that they're in Russia. In this case, the flag is the bulldozer and the consulting services. And that's because, as I mentioned, you can't provide the bulldozers. I will say you can provide the bulldozers up until July the 17th. After July the 17th, no, you can't. Let's back up with consulting services. Russia has been sanctioned again by Canada as it applies to, I think, 28 different services in 11 different industries. And the mining industry looms very large in that prohibition of services. And under the new sanctions that take effect as of June the 7th, you can't apply construction services. You can't use cargo services by water. Think about picking up the coal that we talked about. You can't provide computer services. You can't provide environmental services as it relates to the mining of coal, the mining of metallic ores or any other metal ores, or any other kind of mining or quarrying or mining support services. And we've got here a consulting service. In this, as of June the 7th, that consulting service has been banned. So in this particular scenario, the sanctions say up until July the 17th, you can provide the tractors, the bulldozers. As of now, the consulting services and any provision of those consulting services would be a violation of the sanctions. So again, it's the services that are a problem. It's the equipment that's a problem. Not that they're in Russia, not that you're dealing with a sub in Turkmenistan, not that you're dealing with a Finnish firm. And that's your other layer of complexity. What are we dealing with here in terms of goods, in terms of services, in terms of industries?
So just to be practical about this, I heard you say that the bulldozers are fine up until July 17th.
Yeah.
But as a practical matter, and at the risk of giving legal advice, willy-nilly fashion, if you've got bulldozers in Russia right now, is it a good time to maybe move them out? Is that too bold?
Heavy sigh. So look, it's if you're in there under a contract, the problem that you have is the continuation of the contract with those bulldozers. And so, for example, if your contract says we have the obligation to repair those bulldozers under warranty if they collapse 3 months into this, you can't do that because at that point you're acting under the contract, and that contract has been blocked because of the sanctions. So the idea is you're really on notice not to get as much as you possibly can under the door before the garage door shuts closed. The idea is use that as a grace period to start divesting yourself of business dealing with these particular items in relation to the mining industry. And so remember we talked about at the beginning of this, Canada is very aggressive. It's for a variety of reasons. It's taking a real key role in leading forward on this. And this is one of the areas that it's being very, very aggressive on.
So again, just to illustrate the outer limits of where we're at right now in a regulatory fashion, you use the sentence, there is no crime in doing business in Russia right now on its face.
On its face.
And I guess I'd contrast that to what we would traditionally have called a blockade or an embargo. I mean, we're not talking about Cuba in the 60s, where no one goes in, no one comes out. That's not where we're at right now. You can validly go to Russia, do business. I think you have a series of personal and policy choices to make there. But legally, on its face, that's still okay.
Right. So it is. I mean, there's two headlines here. One is you can do business in Russia, But remember, we talked about at the very beginning, you can't deal in the property of, you can't enter into contracts regarding the property of. So that means you can't use any carriers that are Russian sanctioned or that are owned or controlled by Russian sanctioned parties. So think about trains, think about boats. And in fact, if you use a boat, cargo ship to bring whatever you want out of Russia to refine it in Canada, you won't be able to, because the sanctions say if it's a Russian flagged ship or it's owned or controlled by a Russian, or there's somebody in Russia that will benefit from this, it's not allowed to dock in Canada. So there's the issue of, yes, you can do business, but you have to be very clear that there's no sanction taint to carriers for logistics purposes, but also banks. And as we talked about before, almost every single bank in Russia, legacy bank, is sanctioned. There's a few so-called challenge banks, the virtual banks that are not yet sanctioned. And so think about letters of credit when you want to sell something or you want to buy something. And your counterpart wants to use a very well-known bank in Russia, but that bank is sanctioned. You can't do that. So you can do business, but what makes it difficult is that you need to work through every single element of that commercial transaction to make sure that there's nobody in that entire pipeline that's sanctioned. And that's what makes them so tough. If you just simply had somebody to say, sorry, you're embargoed, okay, it's not great, but I know I can't deal with Russia, and I won't deal with Russia. Now, sorry, just one last point. I will say that the ultimate pragmatic effect of this is, as you mentioned at the beginning of this discussion, a lot of companies are walking away from Russia because it's just too difficult to do business there.
So if you're keeping score, we're now up to 4 dimensions. You've got people who can be sanctioned, both persons natural and corporate. You've got products that can be the subject of sanctions. Yep. You have services like shipping, which can be sanctioned, or banking. Yep. And finally, you have geographies which can be sanctioned, specific geographies. But when I say geography, I do not mean the totality of Russia. Or we are talking about very specific geographies. These are the disputed territories, Crimea, and
the whole Donbass area, every particular area of the Ukraine that the Russian military is currently occupying or seeking to occupy will be subject to sanctions.
So my statement, I think, remains true. On the face of it, you can do business in Russia. You just have quite a complex matrix to walk through before you can comfortably know that you've applied your due diligence in that regard. Right. Let's go to our last scenario.
So why don't I set that up again? And I apologize for sounding like a broken record. Obviously you can't deal with sanctioned individuals. You can also deal with their property, so think assets. Mining projects tend to be very JV oriented, tend to look for partners in mining projects. And that usually involves either the selling of shares or the acquisition of shares. And if we're selling shares, we're getting money back. So we're talking about property of the JV partner. And what the sanctions require all companies looking to JV partners to do is know your partner. They may be perfectly clean on their face, but they may have beneficiaries, some of whom are controlling and some of whom are sanctioned. Now, on its face, it sounds, okay, fine, that's problematic. But there's a new layer to the complexity that makes it even more difficult. And you'll remember at the beginning of the discussion, we talked about the black countries, where we said, just because you're dealing with a country in black, even if it's not a sanctioned country, doesn't mean you don't have a sanctioned problem. And you mentioned Canada. And in fact, Canada is a problem, because a new law that's coming into effect, probably in the next week and a half, will enable the government to go before the court to seek a forfeiture order with respect to property that's owned or controlled or held on behalf of a sanctioned person. So let's say, for example, you have a company in Canada that's got a stake in a nickel mine in the north of Canada, is looking for a Canadian JV partner. Well, it turns out that that company is ultimately owned or controlled by a sanctioned oligarch, let's say. The Canadian government, with this new law, will be able to go to the Superior Court, any Superior Court, and make an application for an order to seize that property. And so you could be a minority shareholder in Canada, and you're standing there, and your JV partner has just lost that nickel asset that you've invested in. And so that's why we said at the beginning, know not only that if you're dealing in a sanctioned country, know your partner.
So in the scenario on screen, you've got a Canadian company, Canco, and an Australian company. I mean, these are Five Eyes allies. These are very traditional military and intelligence allies.
Yep.
Very little is kept from the other. We think of the Australians as cousins. The average person might look at this and say, what's the problem here? Like, what
Right.
does this have to do with Russia?
Right.
And I think you've alluded to it, but
Yep.
talk to us about this scenario for a moment.
Yeah. The reason that this scenario was chosen, because it is, just as you say, it's Australia. It's Australia. It's not sanctioned, considered to be a NATO ally, even though it's not part of NATO. As you mentioned, the Five Eyes, part of a deeper security. And the reason that it's chosen is because even with seemingly, I'm going to use the expression vanilla-flavored, very ordinary companies, nevertheless, you still need to understand who's behind them. Because, again, you can have an Australian company that's got several beneficiaries that in turn, some of them may be companies that in turn may have sanctioned shareholders who are controlling. And why is this important? Because sanctioned companies and individuals are very, very smart at creating all kinds of buffering companies, seemingly legitimate companies, to hide their otherwise sanctioned footprint. And so in the normal course, you would think Australian company, it's not really problematic. But the message that I would give is, we're entering into a JV with you. There's new law that's going to pass that might result in the forfeiture of the asset that we're entering into the JV with. We need to understand who's standing behind you. Sorry if it upsets you, but we really do need to understand who's standing behind you.
So, Cliff, I'm going to move on from the scenarios and talk about what I consider to be a very vexing issue, and that's the issue of minority ownership. We've been using the expression owned and controlled, owned and controlled. Let's talk for a moment about owned versus controlled.
Right.
And the idea that if you're dealing with a company that is controlled by a Russian oligarch who has been sanctioned, well, you have a pretty clear-cut case. What if the company with whom you would like to partner, for instance, in a JV, is not controlled by a sanctioned Russian oligarch, but he does have an ownership stake, albeit minority?
Right.
Is there a magic number?
So the answer is no, there is not a magic number. I mean, the reality is if you're dealing with a shareholder that's got a 30% stake, to me that's a red flag. The question is what constitutes control? And you could have somebody with a 10% stake and still be controlling. And well, how can you have that? Well, that 10% stake sanctioned entity could be a very, very close associate of Putin. Putin is sanctioned. And it's very likely that because of that 10%, Putin has a heavy footprint in the direction of that particular company. At least that's a presumption that bears further exploration. That becomes a red flag. In other words, the 10% is not, well, it's just 10%, let's move on. It's, okay, there's 10%. What else do we need to know? Is there somebody influencing that 10% that's deep within the government that's sanctioned? It could also be a situation where the 10% is a Russian business development bank. And that Russian business development bank, therefore, would have a very, very strong say in the actual direction of the company. Could it be controlling? Possibly. And then finally, one last scenario is you have that 10% sanctioned person who's working very closely with a very close business partner who is the controlling shareholder. And so in effect, you have that 10%, but is working with that controlling shareholder who's not controlling, and in effect, they become co-controllers through that business relationship.
So it's not wrong to focus on control. It's just that you have to have a bit more of an expansive view of how that is defined. And for those involved in the foreign investment world, you are looking for control in fact.
Yep.
And that presumption that although someone is a minority owner in a corporation, they exist and exercise an outsized authority versus their actual percentage control.
Yep.
And that's the analysis you would need to engage in.
Right.
Has this been publicized properly? And I don't mean to have you criticize your old colleagues at Global Affairs. There's a Q&A.
Yeah.
Can you get the answer there?
No.
Okay.
No. Transparency is a difficult issue in terms of understanding. What the Canadian government does is the Office of the Superintendent of Financial Institutions does put out a document for banks to assess control, because for banks, they also need to know who they're dealing with. And they highlight some of the key issues you want to look at. So, for example, does this 10% shareholder have the ability to appoint the CEO or senior officers or several directors? Is that 10% shareholder part of any strategy discussion such that decisions can't be made without that individual's involvement? So there's no actual document that you can look at that's put out by Global Affairs Canada that's involved in the policy of sanctions, but I'd suggest people take a look at the Office of the Superintendent of Financial Institutions. They have issued documentation as to what they consider to be control in fact. And I would suggest you take a look at that and use that as a bit of a guide. And I would think that most other jurisdictions use similar kinds of touchstones to make an assessment of control.
So just to go back to our analytical scoreboard, you've got on one plane analysis around people, products, services, and geographies. On a different plane or axis entirely, you have the issue of owned versus controlled.
Yep.
And the need to do control analysis even in respect of minority shareholders.
Yep.
Am I keeping up?
You are. I'm impressed.
This is good. This is only several months of sitting with you on these issues, so this is good.
Good. I will also say that even if they're not a controlling shareholder, you may have a problem in terms of any declared dividends or any distributions to them, because the declared dividend or the distribution is theirs, so it's their property. And so if you're a JV and you want to declare a distribution or a dividend to one of the shareholders who's not a controlling shareholder, you can't do it because you're dealing in their property. And in fact, banks will freeze that distribution. And so as a matter of practical reality, you may have very, very angry shareholders that are sanctioned that can't benefit from any profits or revenue generated by that.
What happens, I mean, how does a bank deal with that? There's a dividend declared for all shareholders.
Yep.
Where does that money go right now? What's the purgatory into which it falls, and how do the banks deal with it?
So the banks have to freeze that. They could either conceivably freeze the bank account because it contains property of that sanctioned person. And if they don't freeze that bank account, they could freeze another bank account that's set up specifically for the distribution. And once they hold that property, they have an obligation to notify the RCMP, Canada's federal police, that they're actually holding this. And so they have a reporting obligation, a mandatory reporting obligation to the police that they're actually holding the dividends and or distributions of a sanctioned person. And so all of a sudden you have this JV that's got to do reporting. And so there's another reason why you, as the non-sanctioned partner in a JV, want to know, who's my partner in all of this? Do I really want to be involved in a situation where I've got a JV reporting to the police with frozen assets in the bank and trying to unfreeze them and very unhappy shareholders?
We're going to move into our final theme, which is, how do I protect myself? Like, if I'm taking all of this information on board, and I've come to the conclusion that I really have to know my partners, know my counterparties in a very significant and serious way.
Yep.
Walk us through what robust due diligence looks like in the sanctions arena.
Sure. And it just very, very briefly, violations of Canadian sanctions laws puts you in jail for 5 years or fines in any amount at the discretion of the court. And there could also be civil penalties called AMPs for making prohibited goods available, those tractors we talked about or the ball bearings or whatever, to sanctioned parties. So there's a variety of ways in which we can have risk control. And I'll just go through some of them. I don't know if there's a separate slide for that.
Yeah, I'll bring that up.
And one of them is you really need to be doing risk assessment. Where is my investment? Is it in a sanctioned jurisdiction? Who are my investors? Are they coming from sanctioned jurisdictions? And then, as we talked about over and over, it's important to understand who's standing behind the party that you're dealing with. Know your partner. Who are the beneficiaries? Are any of the beneficiaries controlling beneficiaries? Are any of them sanctioned? So there's a real important exercise of due diligence. Now, this can be done through screening software, or this can be done by hiring local counsel in another jurisdiction to find out who the beneficiary shareholders are, or this can be done by engaging with trade commissioners in a particular jurisdiction to get additional information on the particular company and who the shareholders are. And with respect to the buy, sell, and the supply chain, it's know who you're selling to, know what you're selling, know whether you're selling it directly or indirectly, know what banks are involved. Remember, we talked about things like letters of credit. Know who you're buying from directly or indirectly. Just having a really clear idea of that pipeline of sell, that pipeline of buy. And then finally, it's really important to have a very clear sanctions policy with training associated with it. having a senior person who's appointed to manage sanctions policies. And then I would say audits, either an internal audit of an independent person or an external audit every 6 to 12 months. We said we were going to comply. We said our policy was to comply with sanctions. Are we complying with those sanctions? Are there any gaps here that need to be filled? And then finally, with your contracts, I would say you want to include force majeure provisions that take into consideration sanctions issues. Remember, we talked about at the beginning, sanctions are dynamic. You could be providing a service, engineering service, and all of a sudden you're in the midst of a contract where you can no longer provide that service. And as a means of avoiding contractual liability, you'd want your force majeure provision to address sanctions risk. There's, of course, representations and warranties to make sure you're dealing with parties that are not sanctioned. And then immediate termination rights, because you could be buying from somebody that you then find out is purchased by a sanctioned entity, and then you can no longer buy from them. You want to be able to immediately terminate those contracts. And so you want your contracts to address that through termination rights.
So let me ask a difficult question. This is one you and I have sort of debated both publicly and privately, and it has to do with the criminal law. And I suspect you'll come to the same conclusion you had before, but I think it's probably on a lot of people's minds. You have, in the room here today, and joining us virtually, companies big and small. You have blue chip multinationals, and you have, in many cases, very small service providers who are key to the supply chain in every way, but they don't have sanction software. They may not have Cliff Sosnow on speed dial, but they still want to protect themselves. Is there a minimum level of due diligence? Or put differently, if you can say, I took legal advice, I tried my best to get to know who was on the other side of the transaction. I read the newspapers. I looked on the Global Affairs Q&A, and still I have found myself in this situation. I ask this because of the penalties you just referenced, which are incredibly serious and severe.
They are.
Is there a point at which you can throw up your hands and say, look, I did what I could, and therefore I'm not deserving of punishment in this area?
Yeah. So that's a hard question. Thank you very much. No, I'm just joking. So the reality is the sanctions law doesn't require perfection. The sanctions law will be triggered in terms of criminality if there's a willful failure to comply, or what we call also in criminal law willful blindness. I'm just not going to do the investigation, because if I do the investigation, I'm going to find some skeletons in the closet, and I'm not going to want to do that. And if those things are done, it's likely that a court or even enforcement authorities will say, you really didn't do the due diligence you needed to do. The answer is there's no minimum level. The answer is, am I doing a reasonable job in getting that due diligence? So, for example, Global Affairs Canada has a website of sanctioned individuals. The US has a website of sanctioned individuals, as does the EU, as does the UK. Everybody should be looking at those. That's not expensive, it's free. If you're operating in another jurisdiction, I mentioned putting in a phone call to a trade commissioner. Can I get a little bit more information on these individuals? How can I find out who's standing behind them? And so what enforcement authorities will be looking at, and what a court will be looking at, is, did you act reasonably? As opposed to, well, it's just too hard, and I just did what I could. And the question is, well, did you do all that you could? And that means there are tools available. Did you use those tools?
Now, at the beginning of our session, you alluded to something, and it was the concept of extraterritoriality. And I just want to run an impromptu mini scenario.
Sure.
And I know, I'm not supposed to do this to you, but
Nope.
if you are the U.S.-born CEO of a Canadian mining firm, is it accurate to say that you are subject to both U.S. and Canadian sanction regimes simultaneously?
So if you're the U.S.-born CEO of a Canadian mining firm, the answer is yes. You will be subject to U.S. sanctions laws. You will be subject to Canadian sanctions laws. More often than not, that's not a problem. Where it becomes a problem is if you're doing a mining operation in Cuba, because there is an embargo in the U.S. about doing any business in Cuba that applies to U.S. nationals outside of the U.S. There is no mining embargo or Cuba embargo in Canada. In fact, there's laws in Canada that say if you comply while you're in Canada with U.S. law, you will be in violation of Canadian law. And so it's a really, really difficult issue for that U.S.-born CEO. Sorry.
No, that was great. Sorry to you for springing that one on you, but it is a fascinating application of jurisdiction beyond borders that I think people also need to be aware of. With the time remaining, I'd like to just open it up to questions, both from the floor here at our headquarters and for those joining us online. And I think we'll go ahead and do that. And we've got a candidate, an early candidate. And if you care to introduce yourself, great. And if not, you can skip that part. Whatever is of comfort for you.
You can be anonymous if you want.
Mike Peru, do private consulting for the mining sector. You've got up a number of great points, and I've got a few questions. My first one maybe is, you've been talking about sanctions from the black countries applied to Russia and the rest of them. I'm curious about if there's any risk or concern that we should have or could have for the sanctions going the other direction. So the Russians have sanctioned Canadians, business leaders, American politicians. Is there a concern of getting caught up in sanctions going potentially the opposite direction?
Well, I think the answer is sure. You may be dealing with a party that's clean from a Canadian sanction perspective, but that party has to deal with Canada as an unfriendly country under Russian sanctions laws. And so there may not only be a prohibition on dealing with a Canadian counterparty, even if that didn't apply, there are all kinds of export controls now that have been added to the Russian economy to prevent scarce resources from leaving Russia precisely because of the opposite sanctions. So you may be okay, but you may find that your Russian dance partner is absolutely not okay with doing it. And so they also need to do their own due diligence. And that just, you raise a good point, that just increases the level of complexity of it. So,
it's a fascinating question. I have personal friends who have been sanctioned by Russia. They wear it as a badge of honor. But you raise an interesting point. I suppose if I have them over for dinner, I'm also in violation. I don't have immediate plans to travel to Russia, although I'd love to see the country someday. That, and we'll talk about this in a moment, is becoming increasingly unlikely and problematic. Michael Barassa, you've got a question.
Well, I've got questions that have come in from people watching.
Great.
And I think you've covered these already, but then they came in quite early on. But basically, one is there criteria to ascertain control, and I think you dealt with a bit, Cliff. And sort of related to that is, how far do you have to go to satisfy due diligence? I think you also dealt. The question really is there a defense of due diligence? And his example was that earlier on, talked about the coal. He said, your distributor lies to you and says, there's nothing. So you just go with what you're being told?
Yeah.
You have to go beyond that.
You have to go beyond that.
And is there a defense of due diligence?
I think the answer is, in Canadian law, no. In U.S. law, I believe the answer is yes. But in Canadian law, where the due diligence comes in is the willfulness side of the equation. And remember, we talk about you trip over criminal law as it applies to sanctions. And by the way, in Canada, sanctions are considered criminal law. In other jurisdictions, they're not. And so you jump over the criminal law standard of willfulness. There has to be a mental component to what you're doing. What due diligence does is it drains the argument that you were willfully failing to comply. You may not have been perfect in your analysis. You may not have gotten it right. But you have a sanctions policy. It's a comprehensive sanctions policy. You've hired local counsel. You've gone through the papers. You've looked at beneficiaries. You've gone up the tree. You've done what was reasonably asked of you. And so I would make the argument that while it's not a defense in the sense of, for example, and I hate to use this example, of self-defense as a complete defense in a murder case where somebody is threatening you and literally about to kill you, and you kill them in return in self-defense, that's not the way this due diligence would work as a complete defense. But what it does is it goes to the issue of, did you act willfully? Were you willfully blind? And if you've done that reasonable due diligence, I would argue you're not. You may not be perfect, but the law is not requiring perfection.
I have a follow-up, so I don't know if there's other questions here as well. Go ahead.
Okay. Hi.
Hi.
Question about the sort of international applicability of Canadian-specific sanctions. So, hypothetical example of a UK-registered company that has Canadian and many other operating companies in other parts of the world. Do Canadian sanctions apply to the operating companies across the board, do you think? Particularly also as, for example, the UK company having a Canadian employee, shareholder. So it's a question whether Canadian sanctions would apply to a UK registered company with Canadian part ownership, just with an individual. Does that make sense? Sorry, that was a bit of a complicated question.
No. So the UK company itself is not subject to Canadian sanctions.
Mm-hmm.
The Canadians in that UK company are.
Okay.
And I was involved in the sale of the Chelsea Football Club, and I think it's on the public record that one of the persons involved was a Canadian. And I can't give more details than that, but other than to say, even though they were in the UK, the sanctions followed that person. So, and then for the UK Canadian companies, well, they were incorporated in Canada.
Mm-hmm.
And the definition of Canadian is an individual, but also a company incorporated in Canada. And now we start getting into how much is the subsidiary controlled out of Canada. And you start having some really complex
Mm-hmm.
questions about that. And is it organized in Canada, but it's really controlled by the UK company? So is it a Canadian abroad? And so that starts to become a really hard issue. But I'd say as a starting point, I would make the argument that, yeah, that company is subject to sanctions laws as the starting point. The other is, of course, we haven't really talked about this, is the Canadian sanctions applies to any person in Canada. And so the question becomes, what is a person in Canada? And you could have, for example, investment firms that are foreign investment firms that nevertheless sell their investment products into Canada. Are they in Canada? Are they themselves subject to sanctions? And the headline that I would give for anybody wondering about that is, if the person has to deal with filings or registrations or reports and otherwise is subject to the law of Canada, then they're in Canada. But your issue about subsidies, acting abroad, are they quote unquote Canadian? That's a hard issue.
Okay. Thank you.
Michael, another from you.
Mic on? It's on. Okay. So who's the regulator? Who's the cop that comes? If it comes, just a second. I've got more to this. So something goes wrong. That example you gave of a Canadian company dealing with an Australian company, I have to say I thought that was bizarre. That you actually really have to go beyond. Like in that scenario, you have to determine that there's no Russian connection or Russian sanctioned connection. So let's say something goes. You discover something has gone wrong. Who's going to come after you? And is there a mea culpa? Can you say, oh my God, we did do due diligence, but now we've realized there was a mistake. Can you rectify it?
So again, the reason that we mention the Australian company is to say, just simply know who your partner is, because now that the law will be changed to allow for forfeiture of assets and property in Canada, it's always important to know who your partner is. It likely is the case that you're dealing with an Australian company, that Australian company is clean. And you're going to know very, very quickly that Australian company is clean. But I would say that with the passage of this law, you're really, I was going to say playing with fire, but that's not what I mean to say. You're not being prudent, and you're not exercising proper due diligence and finding out who's behind that company. Because if, in fact, you do that due diligence, or you didn't do that due diligence, and the enforcers do find out that there was a sanctioned person, then that issue of did you engage in reasonable due diligence come into play. So who are the enforcers? The enforcers are the RCMP. The enforcers are CSIS, but it's typically would be the RCMP that would actually come in, do the investigating, do the seizure of the assets. And what this new legislation creates, and how it creates it, is now the Department of Foreign Affairs is also an enforcer by actually making an application to the court to forfeit assets in Canada. And so to your point about, well, okay, fine, I think the message that I would give is, this is very serious business, and the fines are very serious. And so it is absolutely critical to do what you can to try to get clarity. And I'll say, as lawyers, we have that own responsibility. Are we dealing with sanctioned persons as lawyers? Because we also have our own responsibilities under the law that prohibits us in certain circumstances to deal with those. So it's reasonable due diligence. As much as you can, use the tools available to go up that corporate chain. It's hard. It's not a pleasant exercise.
Any final questions before we move to our conclusion? One more.
Thank you so much for the presentation. It was very helpful. My name is Leo Lin, work at Sosnow Mining, Director of Finance. So as a director at junior mining company, typically we try to put the money into the ground, but we're also trying to not get ourselves into legal issues. And we're dealing with a lot of Canadian suppliers. And in your presentation, you mentioned, like, say, if we deal with an Australian company, but what about if we're just doing business locally? How much due diligence do we have to do with our existing suppliers?
It's a good question. There's a risk continuum. Remember, we talked about a risk assessment. The chances are, if you're dealing with a well-known supplier, it's different than if you're dealing with a supplier who's a numbered company that has investors in a sanctioned jurisdiction. And I'm using that as a hypothetical. So I'd say if you're dealing with a local supplier, that supplier is well known to you. That supplier has been in the market for a while. That supplier is well known. It's very, very unlikely that that supplier is sanctioned. Where you want to be careful is if that supplier gets sold to a sanctioned party. So you want to start thinking about contracts with your supplier to put in sanctions provisions, to say you rep and you warrant that you're not a sanctioned person, that you're not owned or controlled by, and that if any of these representations and warranties change, you'll notify us immediately. That doesn't mean you can't do business with them. It just means, yeah, I think I've done my due diligence because they're well established in the market. They're well-known players, but nevertheless, I'm going to put something in my contract with them just in case something changes. That, to me, would be a best practice.
Thank you.
Okay.
Well, thanks to everyone both online and in person who's joined us today. It's a tough, dense topic. One of the questions that's been put to me is, well, you know, when does this all come to an end? You know, we think we are arriving at the end of the COVID era. Are we going to come to a place where we finally come to the end of a sanctions era vis-a-vis Russia, at least at this intensity? And I think that the tough answer on that question is that in all likelihood, these sanctions are with us for a very long time. And the reason is that things have been done in Ukraine that cannot be undone. They are the subject of International Criminal Court proceedings or investigations. It is, I think, fair to say that Vladimir Putin will, for the rest of his life, probably only ever be able to visit lands that he has conquered. I mean, this is the sort of imperial motif that he has set up for himself. And I think that the negative externality for him is that will be true in a negative sense. You can't visit anywhere that you don't directly control because you will be subject to arrest and prosecution, along with, very likely, many, many others in that regime. The sanctions portion of this will likely travel with people for a number of years, a long number of years, which means that in turn, those of us who are in law, in mining, and at the intersect of those two industries will have to grapple with these sanctions for a long time. They're not going away. A couple of things that I would listen for in your discussions and that would act as warning signs. The first, in response to the question, do you have a sanctions program? And I've heard this. Well, we don't do business with bad people. That's not a sanctions program. That whatever the due diligence defense is or is not, it's not that. There has to be certainly much more than that. The other thing I've heard is, well, let's just not get into that. Let's not go there. Let's not ask those questions. I mean, that is sadly the foundation of a willful blindness prosecution. And I don't think that's too extreme a thing to say in the context in which we're operating. Sadly, and in conclusion, there are no easy answers. I think it's nice to come to a session and get some answers which are at the easy end of the spectrum, and I don't think we've provided you with any today, and I'll say that unapologetically. And I'll tell you one thing that I followed is I don't dabble in this area. We have bona fide experts who are present. If you think you have a problem, reach out to us and let us connect you with the right people. If you've sat in silence today not asking a question, I would totally understand, given that many of you are sort of active in the mining space. These are not theoretical issues. These are hour-by-hour questions with which you're grappling right now. No one faults you for not sort of putting up your hand in a public forum. Reach out to us and let's have that discussion offline about where you've come from, where you find yourself right now, and what is the proper path out of that predicament. And finally, I think that it is proper to acknowledge that we are all watching this war unfold. Many of us have seen things on the television that maybe we wish we had not. That experience is obviously by orders of magnitude dwarfed. It's a different universe from what people are actually experiencing on the ground. And I think it behooves us all to sort of think past our own legal regulatory problems and be reminded of what real humans are facing in Ukraine right now. With that, please continue to stay safe, and thank you all very much for joining us at this session. Stay well.
Thank you.